Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
If you're not sure what your workplace rights are, this is a show for you. Welcome to Ask a Lawyer. I'm your host, John Scholes. Every week, we shatter myths and clear up the confusion about your employment law rights in Canada and how to get the advice and compensation you need. Joining us, employment lawyer Lior Samfiru, partner at EmploymentLawyer.ca. Now, before we get to questions and phone calls, Lior, tell us why it's important that everyone knows about their employment rights and maybe a case from the past week that we can all learn from and glean something from, right?
No, I find that people generally are not that interested in a lot of legal issues, legal concepts. Not too many people want to know about real estate law or criminal law, even family law, hopefully not. But everyone wants to understand about employment law because everyone works, and it impacts all of us pretty much all the time. And that's why employment law is important. You may not know what to do if you're facing an ultimatum, but if you understand the law, you will know. You may often wonder, hey, my employer is doing this. Is this legal? Can they actually get away with that? Do I have rights? Well, on this show, like we do every week, we'll talk about those things. We'll talk about things you may not have realized that are owed to you, or situations where you have rights. Everyone should know that. You may not know your rights. If you watch the show, you will learn. And I want you to spread the word. Tell others about what you've learned. Tell others about how employment law, of course, impacts you and the rights that you have. In this province, I've said before, we have some of the best employment laws in the world. So it's important that you understand that. And of course, if you ever have questions that we don't cover, you want to have a private chat with me, we'll give you my contact information, phone and email throughout the show so we can have that chat. But now that we know what we want to do, let's go ahead and do it. Let me tell you about a situation that came across my desk over the past few days. I spoke with a gentleman who had to go off for a couple of months because of a serious medical condition. So no problem. His employer let him do that as they should, as they had to. He was off. Fortunately, after a couple of months, he was much better, got treatment, was ready to come back to work, showed up to work, doctor's note in hand saying, been cleared, ready to come back to work. Just tell me when to start. His employer said, well, great. Happy you're back, happy you're better, we want to have you back, but before we do that, we need you to speak to another doctor and get a second opinion. We want to make sure that you're actually really fine to come back to work, so we'll hire a doctor, we'll pay them to review your file, to examine you, to make sure you're able to go back to work. He wasn't comfortable with that. Most people don't want to just go see any random old doctor, and he said, well, I don't want to do that. Well, the employer said, too bad, you have to. That's when he did the right thing and he called me and he wanted to know what are my rights. So let's be very clear. Your employer does not have the right to insist that you see another doctor to verify your medical condition. Your doctor, the one that you have, the one that knows you, is really all that matters. If you have a doctor's note telling you you can go back to work, telling you you can't work, telling you that you need accommodation, all that is all you need, and your employer has to follow that. Your employer cannot question your doctor, can't say we disagree, we want to talk to someone else. Whatever your doctor says ultimately matters. So that's the rule. So what I'm going to do in this situation, I'm going to remind very nicely this employer of their legal obligation. They'll back off, they'll let him go back to work. But remember, your employer cannot demand you see another doctor, never.
If you want to get in touch with Lior and his team, you can call 1-888-861-4555. Email ask@employmentlawyer.ca or visit their website, employmentlawyer.ca. Let's start with our first call of the show, Lior. These calls from our long-running radio shows across Ontario and Canada, for that matter, where we take questions live from listeners about all their employment law issues. First call is coming right now.
I have a friend who works in sales. She's been with this company for about 8 years. When she travels, certain things are paid for by the company. Some things are her own expenses. She still writes off certain things such as gas, mileage, and etc. She has to give them her schedule, her availability, which is 7 days a week. She doesn't work for anybody else, exclusively for him. Recently, they had a cutback and she got let go. She got no severance. Is she not entitled to severance?
Wow, what a problem for her. She's worked there for 8 years. She's been let go and not paid anything. This comes down to whether, in fact, she's an employee or a contractor. Now, she's worked there for 8 years. She's working only for them. They tell her what to do, where to go. She is likely an employee, and that means she's owed severance. People are misclassified as contractors all the time. Most people, in fact, that believe they're contractors, in the eyes of the law, are really employees, and that means they get severance if they're let go. Now, in this situation, John, even looking at it from the company's perspective, at best, she's a dependent contractor, which still means she gets severance. Okay, how much severance? That's the question. Of course, that's literally where the money is. Yep. Let's go to EmploymentLawyer.ca. Let's use our severance calculator tool, which anyone can use free and anonymously, and let's see how much she's actually owed. So if she is an employee, she's not a contractor, she's been misclassified, she's been there for 8 years in a sales role, 54 years of age. We see on the screen right now she's owed 12 to 14 months of severance. Now, this is someone, John, that has not been paid anything because her employer says, oh gosh, no, you're a contractor, we don't know you anything. She's owed more than a year's pay. Same with you at home. If you've been misclassified and this whole time your employer treated you as a contractor when they shouldn't, if you lose that job, you are owed severance, and you absolutely have to call me right away.
All right, let's take a quick break, Lior. When we come back, employment lawyer Lior Samfiru from EmploymentLawyer.ca. We'll look at times when you need to watch your back at work. Ask a Lawyer returns. Hang on.
Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
All right, welcome back to Ask a Lawyer. Employment lawyer Lior Samfiru from EmploymentLawyer.ca is tackling questions about your workplace rights. Get in touch with Lior and his team today. Email ask@EmploymentLawyer.ca or call 1-888-861-4555 or go to EmploymentLawyer.ca. Always a good plan. We'll get to more phone calls and questions in a moment, but first, today's main topic, times when employees need to watch their back. And some key takeaways from our viewers. First one, you need to watch your back when your employer starts giving you bad performance reviews.
So we're talking, John, about a situation where if this happens to you, that's a bad thing. There's probably something bigger going on there. So you need to watch your back. You need to know how to respond. The example you gave, probably the best example, and that is you just get negative reviews or put on a performance improvement plan. So let's be clear. When an employer does that, usually it's a way to build up a case against you so they can try to let you go for cause. So it's not just a one-off thing often. It's really part of a process designed to maybe push you off and maybe do so without having to pay you. So you can't just ignore it. You can't assume it's going to just be fine and think, well, I don't have to do anything. If you're put on a performance improvement plan, you want to also point out to your employer what they've done wrong or what you disagree with. So if you're put on a performance improvement plan, you don't agree with what they say, put that in writing. Make sure that you're not considered to have accepted that. By doing that, and I'm saying, by the way, be professional and be courteous, but by doing that, you're going to make it that much harder for the company to let you go for cause. It helps you preserve your job and certainly preserve your severance entitlements, so don't just ignore a negative performance review.
All right, next one is we discuss times when employees need to watch their back. You've been asked to sign a new employment agreement.
Even a bigger issue,
Yeah.
okay? If you're already working, you have a job, everything's fine, your employer shows up to you one day and says, hey, we need you to sign a new employment agreement. It's bad news. I can almost guarantee you that that agreement contains terms that you don't want. For example, it could limit your future severance by tens and tens of thousands of dollars. It may give the company the right to change your pay, to change your job, to put you on a temporary layoff. Very, very bad news. You don't want to accept that. It's not there for you to help you. You're better off not having an employment agreement. And by the way, you can't be punished for refusing to sign it. So you can tell your employer, no, I'm fine with the way things are. I'm not going to sign that. You can't be punished for that. Or at a minimum, send me the agreement. Let me see what it says before you go ahead and sign it. Watch your back. Be very careful.
And we're running through times when employees need to watch their back on Ask a Lawyer with employment lawyer Lior Samfiru. Third on our list here, the employee has made changes to your job.
Very important, because anytime your employer makes significant changes to your job, that concept of constructive dismissal comes to mind. An employer does not have the right to make those significant changes, to change your job by more than, say, 10 or 15%, to change your shifts, your hours, to relocate you, to demote you. And anytime they do that, that could be a constructive dismissal. But why do you say watch your back? Because if you just let it happen, they gave you a pay cut, you want to be the good soldier, you accept it and continue working. By doing that, you've given them the right to do it again. And the next time they reduce your pay, or the next time they change your job, you won't be able to do anything about it. So definitely don't open that door. Watch your back and stand up for your rights.
Times employees need to watch their back. Number 4, your employer isn't being cooperative in accommodating your medical restrictions. How about that?
Your employer has that legal obligation to accommodate you. And oftentimes what I see is employers saying, oh, that's just too difficult. You need too much of an accommodation, so we don't have to go that far. No, an employer is legally obligated to provide that accommodation if that's what's required by a doctor. And too often employers don't try hard enough. And that's a human rights violation. That's a big deal. If your employer won't accommodate you, won't cooperate, won't give you what your doctor says that you need, call me and I'll make them do it.
Okay, Lior, last point, when employees should watch their back, you've been handed a termination letter. Wow.
Well, the reason why we say that and we put that on this list is that termination letter, and I'm clairvoyant somehow. Without even reading it, I can tell you that letter provides you for less than your entitlements, a lot less. In 90% of cases, what you've been offered is a lot less. So you have to call me. You have to go to EmploymentLawyer.ca and use the severance calculator so you don't accept less than what you're owed. Even if you're feeling the pressure, once you sign it, it's too late. Please do not walk away from your rights.
EmploymentLawyer.ca, that's the easiest way to contact Lior Samfiru and his employment law team for help. Let's jump to another phone call from one of our long-running radio shows, Lior. Here we go.
Is it a part of law or whatnot that a person hired or not hired has a 3-month window where either party can let the other one go without notice?
So obviously, John, this touches on the probationary period. And so many people, I would even say most people, assume that probationary period is automatic, that every time you start a job, there's that 3-month or whatever probationary period. No, it's not automatic. A probationary period does not exist unless you sign an employment agreement that creates it. So a probationary period, you're only on it if you sign an employment agreement that says in the first 3 months you're on probation, and during those 3 months we can let you go without any payment. It's not there otherwise. And because of that, in many cases, if you didn't sign an employment agreement like that, even if you're let go in the first 3 months of employment, yes, you are owed severance. And that severance could be significant. You may have worked for a company for 2 months and you're let go. You could be owed 2, 3, 4 months of severance. So short service, even less than 3 months, does not mean no severance. Severance is still substantial.
Let's take a short break, and when we come back, we'll talk about your rights if your department is shut down and what happens when your employer favors a coworker who's harassing you. More to come on Ask a Lawyer. Hang on.
Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
Welcome back to Ask a Lawyer. Employment lawyer Lior Samfiru from EmploymentLawyer.ca is taking your questions about your workplace rights. If you want to get in touch with Lior and his team, you can call 1-888-861-4555. Email ask@EmploymentLawyer.ca or visit their website, EmploymentLawyer.ca. Still have lots more to discuss. Here's another call from our long-running radio show. Lior, let's listen in.
I worked for a large corporation. I was packaged out. I was told it was a result of my department shutting down. I later found out the same day that I was the only manager that was packaged out. But I know at the time I was performing better than a lot of my counterparts. So I did sign my package, but I just want to know what my rights were if I feel that I was wrongfully dismissed. I was there a total of 8 years. I was 37.
John, every single week, I get calls, I get emails from people that have realized, wait a second, maybe I shouldn't have signed that severance package. They call me after they sign it. And that's one of the very few times that I can't do anything. Once you sign off on that severance package, unfortunately, we were talking about that before the break, that's it, it's done, it's over. Even if you felt the pressure, which most people do, even if you find out after the fact that it was a terrible deal. So despite that pressure, despite what you feel, please, please don't sign that offer. Your legal rights don't expire on that Friday deadline that they give you. In fact, they don't expire for 2 years. So there's no reason in this world why you would accept that offer without speaking to me. Now, this person says, I feel that they probably gave me something that's not appropriate. It's after the fact, but let's still see how much he should have gotten. So to do that, our viewers know what I'm about to do. I'm going to go to our severance calculator tool, which you can find at EmploymentLawyer.ca. You do that yourself. And let's see what the numbers really are. So this guy, we know, is a manager. He's been there for 8 years, 37 years of age. He was let go because of restructuring. You see on the screen, he's owed easily around 12 months of severance, 12 months. He likely accepted less. Unfortunately, you can't go back and fix that. That's why you have to do it right the first time. If you're let go, go to EmploymentLawyer.ca, call me, but let's make sure that you get everything that the law says you should have.
And for you to get in touch with Lior and his team, email ask@EmploymentLawyer.ca, call 1-888-861-4555, or visit EmploymentLawyer.ca. We'll take a look at another situation your firm has come across recently. It says, I was being constantly harassed by a new coworker. I finally lost my patience and filed a complaint with my manager. I guess they liked my coworker better because they quickly excluded me from routine meetings and emails and have made my life extremely difficult these last few weeks. What are my rights here, Lior?
Well, it certainly sounds like this is an employer that got it wrong. Why? Because if you're a victim of harassment, and unfortunately that is quite common, quite unfortunately, but if you're a victim of harassment, you have the right to have that complaint of yours being treated seriously, taken seriously, the employer to investigate, to conduct a proper, unbiased investigation, and to rectify that problem when it's done with the investigation. What they can do is essentially punish you for complaining about the harassment. And if the employer says, well, we may not be able to conduct an unbiased investigation because there's someone else that there's a relationship with, then they have to bring an outside investigator. So if this employer really dropped the ball on the investigation, on dealing with the harassment, that could be a constructive dismissal. Depending on the type of harassment, it could also be a human rights violation. So there's a lot that this employer did wrong. Bottom line is this: you should expect your employer to take your harassment complaint seriously. If they don't, if they drop the ball, if they don't deal with it, if they don't properly investigate, call me, let me deal with it. Potentially I can get you out of there, get you compensation, so you have that right.
Okay, we'll take a break and return with Lior Samfiru, partner at EmploymentLawyer.ca, or you should call the Ministry of Labor if you're refused severance pay. You think so? We'll find out next on Ask a Lawyer.
Do you have questions about your employment rights? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Wednesdays at 9:30 p.m. on CP24.
All right, welcome back to Ask a Lawyer. Lior Samfiru from EmploymentLawyer.ca is answering your employment law questions. You can connect with his team by calling 1-888-861-4555. Email ask@EmploymentLawyer.ca or visit their website. That is EmploymentLawyer.ca. All right, Lior, time for another question. This one comes from one of your live streams, those on Facebook and YouTube, which people can find. You can join in at STLawyers.ca. At STLawyers.ca is how you do that. Here it is. After 10 years in a professional role, I was let go due to economic pressures in Canada. My boss told me that for various legal reasons, he doesn't have to give me any compensation whatsoever. Not even the bonus that I had earned earlier this year. Is something the Ministry of Labor can handle? Yeah, Lior?
Various legal reasons. That sounds very convincing. I don't know about you. It's convincing me. And by the way, when I go to court, that's how I always talk to the judge. I have various legal reasons. Trust me on that. That's silly. That's ridiculous because there's no such legal reasons. Of course, you are owed severance if you lose your job. Of course, you have to get paid your outstanding bonus. And your employer does not have reasons, legal or otherwise, not to pay that. Okay, very important. But that's not even the question. The question was about the Ministry of Labor and whether the Ministry of Labor can help in that situation. So I want to be very clear so that no one misunderstands. The Ministry of Labor cannot help you if you lose your job. They cannot do that. The Ministry of Labor can only help advise and enforce your minimum termination entitlements. Those minimum entitlements are just a fraction of what you're actually owed. So, for example, your minimum entitlements may be to 2 weeks severance. Your full entitlements could be to 8 months severance. That's a massive, massive, massive difference. So that's why when it comes to losing your job, you cannot go to the Ministry of Labor. You cannot seek their advice. When you lose your job, you have to speak with someone like me. I'm an employment lawyer now. If you don't like me for whatever reason, you can speak to another employment lawyer. But that's what you have to do. The Ministry of Labor cannot help you, so please do not make that mistake.
What if I go there and I start a claim with the Ministry of Labor, I watch this show and I go, okay, forget it, I take it back.
But wait, it gets worse. If you actually file a complaint with the Ministry of Labor, after 2 weeks, you were prevented from withdrawing it.
Right.
You cannot change your mind, and then that means you're barred from pursuing your full entitlements. Please don't let that happen. I've spoken with dozens of people that over the years have lost literally tens of thousands of dollars. Why? Because they went to the Ministry of Labor when it comes to losing their jobs. It's okay, by the way, John, to go to the Ministry of Labor if you have a vacation pay issue, if an overtime issue, if you have a statutory holiday issue, absolutely fine. Not when it comes to losing your job. They cannot help you in that situation, and it's very misleading when you go there. So do the right thing. Speak to me. Go to EmploymentLawyer.ca. Use the severance calculator. My gosh, it's free. It couldn't be any easier. So do the right thing, the smart thing, if you lose your job.
All right, Lior, great stuff as always, and thank you so much for being here today. You can catch legal experts from EmploymentLawyer.ca on Ask a Lawyer every Wednesday on CP24. For more information on the show and EmploymentLawyer.ca, visit cp24.com/askalawyer. If you'd like to have your questions laid out, answered live on air, tune into the Employment Law Show hosted by myself and Lior, Sundays from 1 till 2 p.m. on News Talk 1010. You'll want to join us next week as well as we drill down on how to preserve your workplace rights. Thank you so much for watching.